This case involved an order compelling arbitration, which is not appealable, as many of our listeners will know. And we all know that writs are a low percentage proposition, taking them up to the Court of Appeal. So was this a tough call to decide to take this up?
Yes, well, I don't know about you, but I almost never recommend taking a writ petition. I always feel terrible, having to let people down. I know people have high hopes that wrongs can be righted quickly, and I say even if the wrongs can be righted, it won't be quickly or rarely. But in this case, when we were evaluating it, we found a very recent second district case that was very similar to ours that involved multiple contracts, some of which had arbitration agreements and some didn't. And so what we actually did was we recommended they make a motion for reconsideration because there was still time to do that. Because I think you guys probably know this as well, your best chance is to try to get the trial court to reconsider versus going up. And so they took the shot, but the judge denied the reconsideration motion. But at that point, we had the new case in the record. We were able to develop that argument in the trial court a little more before we took the writ.
Okay. Well, so tell our listeners a little bit about the case. We don't want to bury the lead here. How did it get to the point where you first saw it and decided to take it up on a writ?
So when we saw the other second district case, it was Division 1 had taken it. As you know, on the second district, you could end up in the same division. And so because there's always that chance, and we knew they would take their opinion very seriously, we told them we never recommend writs per se, but we say, if this caught someone at the right moment and they were interested, this is the kind of writ they might take. And that's because it's a really quick moving area. Arbitration, there's new cases coming out all the time. And then there was the interplay with the federal law and a case called Shine. And in this case also, sometimes it's hard on a writ petition to show prejudice. Why should the court step in now instead of waiting till the end? And in this case, because the prejudice was so clear, having to do a whole separate arbitration proceeding versus going right back into the trial court, we thought that the pieces lined up enough that we could recommend, if the client was willing to take a swing, that it was a worthwhile writ.